Hello friends, in this section we are going to discuss various types of contract. In connection with contracts, there are basically three broad classifications. The first one is based upon the basis of enforcement. The second classification is based upon the basis of is based upon creation, and the third one is based upon its execution. Now let us see one by one what are the basis of enforcement of contract. On the basis of enforcement of contract, the contract can be broadly classified into five sub-different categories. That is, it can be a valid contract, it can be a void contract, or it can be voidable. Apart from that, it can also be an unenforceable contract or an illegal or unlawful contract. Now let us discuss one by one what is meant by valid, void, voidable, unenforceable and illegal. As already said, on the basis of enforceability, the contract can either be valid, void, voidable, unenforceable or illegal. So what is a valid contract? The terms and conditions of a valid contract are such that it is enforceable in a court of law. Hence, it can be termed as a valid contract. As far as void contract is concerned, this contract is not enforceable in court of law due to certain missing elements which are essential for a valid contract present in it. The third classification is voidable contract. That is, in this particular type, the consent of the parties entering into contract is not free. The contract is either made under pressure, which can be either mental as well as physical. So such contract is voidable at the consent or at the instance of one of the parties to the contract but not the other. The consent which has been obtained by fraud, if it is proved, then the person giving the consent is having the right to invalidate the contract. This contract is neither valid nor void, or we can say it is voidable. That means if the party to the contract decides to declare the contract as void, it is, if given opportunity, then it can declare the contract and the contract becomes void. Till then it is valid. Hence it is called as voidable contract. Illegal contracts. If the object of entering into contract is to serve an illegal purpose or unlawful object is there, then the contract is illegal on the basis of the terms and conditions which are not recognized by law. The last classification says that a contract can be unenforceable if the contract lacks the legal formalities which are essential for entering into contract. Then it suffers from technical defect, such as if it misses the signatures of both the parties, or if there is no stamp on the parties. After ratification of technical defect, again the contract becomes enforceable and valid. But until and unless the technical difficulties are not removed, it will remain unenforceable contract. On the basis of creation of contract, the contract can further be subclassified into three different types. That is, it can either be expressed or implied or even quasi-contract. Now what are these? Let us have a discussion on it. Express contracts. The contracts where there is an expression or conversation between the parties entering into contract is called as express contract. It can either be in writing or it can be oral. So this particular type of contract where the offerer or the proposer express his proposal is called as express contract, and the acceptance is also given or expressed. The second classification is called as implied contract. If there is no expression, just by way of conduct, the formalities for entering into contract are completed, then that particular contract is considered or called as implied contract. For example, sitting in a bus can be taken an example to implied contract between the passenger and owner of the bus. The last classification is that of quasi-contract, or the last classification on the basis of creation is quasi-contract. In quasi-contract, there is actually no offer and acceptance. There are no contractual relationship between the parties, but it is created on the basis of virtue of law, and it is discussed under section 68 to 72 of the Indian Contract Act, which will be dealt with or discussed in detail in the upcoming lecture series. The third broad classification of contract is on the basis of its execution. On the basis of execution, a contract can be classified as executed, executory, bilateral, or unilateral. We say a particular contract to be executory. That means that the consideration is either the promise of performance or an obligation, and it can be performed sometimes in future. It is yet to be executed. Here the promise of consideration simply cannot be performed immediately, but has to be performed sometime in future. Hence it is called as executory contract. Whereas in case of executed contract, the contract is entered into between two parties, and both the parties who have made a promise to each other have performed their part of performance. Here basically whatever the stipulation of the contract was there has been carried out, or the contract has been completed. That's why it is called as executed contract. Bilateral contract, when the consideration in both the directions, that is of both the parties, are to be moved after the contract, it is called as bilateral contract. For example, if a contract is entered into between X and Y on a particular date, according to which the performance of contract has to take place, so it is called as bilateral contract, because on the particular date the amount will be the decided amount will be given and the product will be taken. That is why it is bilateral. Both the parties are going to perform the contract after a particular date. Apart from that, unilateral contract. In this particular type of contract, one of the party has completed its part of performance and other party's part of performance is awaited. So it is called as unilateral contract. Example, if a party has lost one of its valuables and the finder of that valuable tries to search the party, then the party whose valuable are returned, that party offers to pay a particular amount of money as a gratuitous payment. Here, because one of the parties had already performed its performance, it will be called as unilateral contract. If anyone has any doubt, you can kindly comment in the comment box and you will get an answer or clarification for your doubt. Thank you.
Thanks for watching. Please like, subscribe and share.